Good morning, everybody. Hope everyone is doing okay. It is Monday morning, January 3rd. And oh my goodness, this year is off to a good start. I've got an update to the Montana case, which there's some interesting things. And first I want to do a disclaimer that I do not have any legal training. I am only reading the documents, and trying to understand them the best that I can. I will put a link down below to our website where these documents are. And I want to thank our source so much for sending me all of these documents, because Watchtower is pulling the same shenanigans that they are with the Pencava case in Illinois. Trying to delay, confuse, anything to delay the case and producing any evidence. But it looks like the court is going to fine them daily for not producing these documents. And our source in Illinois and I passed these on to her, and then she gave them to the prosecuting attorney there in Illinois, just for basically to show Watchtower's MO. This is what they do. And in Montana, they're getting fined daily for not producing these documents. Now, I'm going to start with the May 28th, 2021 document, and I'm not going to read this whole thing. It's 11 pages, so I'm just going to kind of skim through it, so you can kind of get the idea. Now, we know this case involves sexual abuse. In 2004, the pedophile sexually abused the victim. During the time of the abuse, defendants' elders, including elders in Montana, allegedly learned that he was an admitted pedophile. Plaintiff asserts that the elders and others whom they assert are and were defendants' agents were negligent. Plaintiff asserts that defendant Watchtower also knew about the abuse through a call from a local elder to Watchtower's legal department, and we know that's what they do also. Now, this is what was interesting here on page 2. In its Rule 16 scheduling order, entered after conferring with the parties, the court permitted discovery to be reopened only concerning documents relating to the child molester CM database. So from here on out, I'm going to refer to it as CM database. The plaintiff served written discovery on this narrow subject matter, but the defendants refused to answer. This motion followed. The discovery at issue as follows, and it was very specific. Request for production number 2, produce all pages from the CM database that include references to Nunez, one of the victims. Request for production number 3, produce all pages from the CM database that include references to the pedophile. Request for production number 4, produce the 7 pages that you withheld from production as described in Exhibit B. Did Watchtower withhold documents? They wouldn't do that. They're honest in all things, right? Yeah, heavy sarcasm intended. Request for production number 5, produce all 10 pages of the document identified as item number 1 on the privilege log attached as Exhibit C. And I don't know what those are at this moment. Request for production number 7, produce all pages from the CM database that include references to McGowan, another survivor. Here on page 3, when was the database created? During the first trial, defendants produced 3 of 10 pages of the document at issue. X's A and C to plaintiff's motion Exhibits A and C to plaintiff's motion. The 3 produced pages were publicly disclosed. Defendants have referred to the entire 10 pages as a running log, and they list it as a single document in their privilege log. So, for Jehovah's Witnesses to say that all of us are lying apostates about the CM database, we know who's lying now, don't we? They do have one. And they are refusing to produce these documents the court is asking for. Exhibit A to plaintiff's motion. Plaintiff asserts and defendants do not dispute, that's an important thing, do not dispute, that all pages concern the sexual abuse involving 4 people, but that the withheld pages only concern 3 of those people. So there's more victims mentioned in this. Defendants assert that these 3 pages and the remaining pages are protected by attorney-client and/or work product privilege. Joel Taylor, Watchtower's lawyer, represents all defendants. Mr. Taylor is also an in-house lawyer for Watchtower. Wonder if he's certified to practice in the state of Montana. That would be my first question. He produced the 3 pages to the plaintiff. Exhibit C to plaintiff's brief. It goes on to defend that. Down here on page 3 at the bottom, it says the elders are agents of the defendants. So if they claim that elders do not represent them, they're full of it, because they are agents for the defendants, and that's why they're just as responsible and just as guilty as Watchtower is. Okay? McGowan notified elders, agents of defendants, that Reyes was a pedophile. The privilege is asserted by the principals, the defendants, and there are no separate privilege claims by the elders. Defendants assert that the plaintiff has not made a cognizable argument the defendants waived the work product privilege, and that the attorney-client privilege does not apply. Now, Watchtower keeps saying that this is, lawyer-client privilege or clergy-penitent privilege, like what they're trying to use in the Pinkava case. But they have here the Montana Rule 26B1. Parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense, including the existence, description, nature, custody, condition, and location of any documents or other tangible things, and the identity and location of persons who know of any discoverable matter. So they have a right to know. See, a party is entitled to discovery if the matter sought is not privileged and is relevant to the subject matter of the action, and their CM database is relevant. For example, here at the bottom of page 4, it says the purpose of discovery is to promote the ascertainment of truth and the ultimate disposition of the lawsuit. Discovery fulfills this purpose by assuring the mutual knowledge of all relevant facts gathered by both parties, which are essential to proper litigation. So they have a right to this information. Watchtower does not have the right to withhold it. Now, when you skip down to page 8 of this May 28th document, first full paragraph at the top, in this case, the evidence reflects that the defendants voluntarily waived any claim privilege by disclosing selected excerpts of the document in question during the first trial for apparently strategic reasons. While defendants argue that their disclosure during the first trial was the result of an off-the-record order made by Judge Manley, they offer no evidence of such an order, and no evidence of such an order appears in the record or in the defendant's briefing. You mean they lied? Further, there is no evidence in the record that the defendants objected to any such order. Thus, even had an order been issued, the law of the case doctrine militates against reconsideration. Oh my goodness. They really are, something else, the way they try to protect their own backsides. Here on page 9, under subheading number 2, defendants objected to producing the balance of the document because it concerns acts committed by one or more third parties. This objection likewise is disingenuous. The person described as a third party is the defendant's key witness, McGowan. The document also relates to Rise, who defendants made a party. Discovery of information and evidence about a primary witness is at the very least likely to lead to probative evidence about the claims or defenses and or the bias of witness McGowan. Here on page 10, under subheading number 3, the discovery requests are neither vague nor ambiguous. Defendants object that the discovery request is vague and ambiguous, representing that they do not know what the words CM database mean. The court finds this objection to be frivolous and interposed for an improper purpose. It is clear to the court and that the defendants understand what the plaintiff is seeking, regardless of whether they choose to call the information sought something different. The defendant's counsel discussed the CM database with the court during the Rule 16 conference. So they knew what they wanted, knew what they were talking about. Because like I said, they even discussed the CM database with the court during the Rule 16 conference, which led to the court scheduling order and never objected that they did not understand the term. So Watchtower knows exactly what the CM database is. And then the defendants finally object that the discovery sought is overly broad. This objection is at best a shotgun, blanket objection expressly disproved in the litany of Montana Supreme Court and federal courts. Oh my goodness. So then at the page 11 here, the final page of this order, defendant shall immediately fully respond to the following discovery request. And then they have a list of the request. And that is interesting. That is interesting. Now, there's a June 23rd order. And this one is also interesting because same thing. Defendant shall immediately fully respond to the following discovery request. And then they go through all of the requests for, this evidence once again. And looks like Watchtower filed a erroneous document. On June 11th, 2021, the defendants produced a notice of submission for an in-camera review. Not only the one-page erroneous document described above, but also the 10-page document from their child molester CM database. Oh, they can produce documents from that CM database. Going on, which the court expressly ordered them to immediately produce to Nunes. Not only did defendants defy the court's order, they asserted they do not understand the court's May 26, 2018 order to compel production. This statement of confusion defies credulity and objectively disingenuous. Then they have listings of the order. And then they have here on page 3, one of the rules here in Montana authorizes a district court to sanction a party for failure to comply with a court order compelling discovery, including by dismissal of an action or by entering a judgment by default. Yep, acted willfully. That's what they did. Yeah? Undermine the integrity of the entire proceeding. Over here on page 5, first full paragraph. The defendant's decision to violate the court's order and not produce the 10-page document directly to Nunes as ordered, instead producing it for review in camera, claiming that it did not understand the court order, was not substantially justified. Oh my goodness. One interesting thing here on page 7. at the top it says, accordingly, it is hereby ordered, all capital letters, defendant shall immediately, bold print, underlined, produce the 10-page CM database document that the court ordered produced in its May 26, 2021 order and the 1-page erroneous document to Nunez. At trial, defendant shall not suggest, argue, imply, elicit, or try to elicit any testimony or offer evidence suggesting that they had no notice that Reyes was a pedophile. This prohibition applies during all stages of trial, and they're going to have to reimburse for reasonable costs and reasonable attorney fees with the motion to compel production of the documents at issue. Reimburse Nunez. Good. Good. All right. Now, I also have July 22nd, 2021. Order enforcing May 26, 2021, order assessing sanctions and attorney's fees. This court issued orders on May 28, 2021 and on May 23, 2021, and June 23rd, I just went through those, in which it set forth relevant law on discovery and its expectations of all parties during discovery. The May 28, 2021 order compelled production of certain specific documents by Watchtower. Watchtower not only flouted its disobedience of that order. What happened to obey the superior authorities, Watchtower? Oh, you tell the rank and file to do that, but you won't do that. They not only flouted its disobedience of that order in subsequent pleadings, it asserted that an order issued by Judge Manley was the law of the case and that therefore it is confused about this court's order. They're not that stupid. And seeks guidance before producing documents the court has ordered produced. The court finds Watchtower's argument to be frivolous and specious, interposed solely to obstruct and delay. See, this is deliberate by Watchtower. They're not obeying the superior authorities, but yet they want the rank and file to. See, they pick and choose what they're going to obey from the superior authorities. Based on the court's review, we're on page 2 now. Based on the court's review of Watchtower's documents submitted for in-camera review, the court immediately recognized Watchtower's obstruction and issued another order, this time assessing sanctions. See, obstruction of justice. That's a criminal offense in this country. Watchtower defied that order and continues to refuse to produce 22 pages of documents and unabashedly misrepresents the truth. Watchtower misrepresent the truth? Imagine that! As to documents the court expressly ordered it to produce, Watchtower asserts that it complied and it's simply waiting for the court to address its embellished claims of privilege and its confusion and its claim that a previous order issued by Judge Manley before the first trial supersedes this court orders. Oh my goodness. And I'll also put the link, or I'll put these documents in there too. See, they're opposed to the motion to compel. They didn't get them all the information. Here on page 5 at the bottom, it says the court has discretion to determine whether a party has chosen to callously disregard their opponent's rights and to determine appropriate sanctions, and then they name another court. The Montana Supreme Court expressly approved judgment by default as a sanction in the face of blatant, systematic, willful, and bad faith conduct. And they cite another case. The court concludes that Watchtower has been deliberate in its violations of the court's orders and the plaintiff's right to discovery. Its claims that it could not understand the plain language in the court's orders are absurd and frivolous. Even I understand that, and I don't have any legal training. Oh my goodness. That's saying, we're sorry, we can't comply, we're too stupid to understand what you want. The court expressly warned that it will not tolerate further obstruction and will consider sanctions for similar conduct in the future. And then they go to name some more rules. However, it follows the guidance of the Montana Supreme Court and will not tolerate this level of discovery abuse and will strongly consider the ultimate sanction of judgment on liability. Defendants are ordered, once again all capitals, to produce all withheld discovery, including any that they continue to claim is privileged and including the 22 pages still in dispute. And then they have a list of the court orders sanctions as follow. And here on page 8 at the bottom, number 3, Watchtower and all defendants, this includes the congregation, Watchtower and all defendants shall be jointly and severally liable for a fine of $500 per day for each day after the date of this order in which they have failed and refused to comply with this order and the orders dated May 28th, 2021 and June 23rd, 2021. So we're looking at what, 7 months of fines of $500 per day for each day they do not comply? Love it. Love it. You know, no wonder they have to beg for money from the rank and file. If the rank and file knew what they were paying for. Oh my goodness. Yeah, rank and file. I'd love to, all of them to know that your donations are going to pay legal fees, and especially for Watchtower not complying to the court, you know, not obeying the superior authorities, having to pay $500 per day. And we know about the California case. That racked up to what, about $4 million in sanctions and fines? Now I looked up this word severally, and it means separately or individually, each in turn, the partners are jointly and severally liable. So they're all liable. So that was, you know, good to know. Love it. Number 4, Watchtower and all defendants shall pay to the plaintiffs $11,075 to reimburse them for the attorney's fees and costs associated with this discovery dispute. So good. They have to pay the survivors' legal fees. I'm glad to see that too. So I know a lot of information, and like I said, I will put the link down below so you can go to our website and grab these documents. And thank you so much for watching, everyone, and you have a wonderful week. Bye.